Hello, and welcome to the Thompson-Coburn webinar on the Jobs Act. My name is Emily Murphy, and I'm here with my co-presenter, Michael Hawthorne. We are members of the Thompson-Coburn Corporate and Securities Practice Group, and we're both based out of the firm's Washington, D.C. office. The firm has over 380 attorneys nationwide with offices in St. Louis, Belleville, D.C., L.A., and Chicago. And we are ranked in the first tier by U.S. News & World Report for our corporate and securities practice, both nationally and in Washington, D.C. What is the Jobs Act? It is short for Jumpstart Our Business Startups Act. This is a federal law that was signed by President Obama on April 5th, 2012 in an effort to revitalize the U.S. economy and encourage investments in small businesses. So we've just passed the third anniversary of the Act, and it basically is just a break of securities regulations in order to get small businesses into the game. The question now is whether this has led to any job creation now that it's 3 years old.
One of the things that we're going to try to provide you guys with is the context of the Jobs Act. But before we do that, this slide breaks down the 6 title acts that there are. There's really 5 relevant sections or groupings of it. Title I deals with the IPO on-ramp, and we're going to jump into some of these in a little bit more detail on further slides. But the IPO on-ramp has been somewhat successful in terms of, for emerging growth companies, they've relaxed a little bit on the accounting rules that you have to have, like 2 years worth of audits versus 3. But probably one of the more important things they did was you can file confidentially with the SEC, because there used to be, the way it was done, you had to file with the Securities Exchange Commission, and if there was a problem with your offering and you had to pull your filing, it wouldn't be good for your public relations. So now you can file with confidentiality. Title II is a modification to the Reg D safe harbor, where 506C allows you to do general solicitation, which is kind of an oxymoron versus what the section really is, a private placement. So you can now do a public offering, in essence, through a private placement exemption. Title III, which is the crowdfunding, which gets a lot of press, and people talk about, oh, let's go do crowdfunding, or you can do crowdfunding now. Well, technically, no, not in the sense of the Securities Exchange Commission, because the rules have not been published. There's been a lot of criticism of the Securities Exchange Commission for not getting all the rules out, but somewhat in defense of the Securities Exchange Commission, they've asked the SEC to do a lot of things while also tightening their budget. So there's mixed messages there. I mean, they want it all done, but they tighten their budget. Title IV is Rule 144A, or Emily always likes to say,
Reg A plus.
A plus, Reg A plus. One of the main things that they did was they increased the limit from $5 million to $50 million. And then Title V and VI deal with, one of the issues that can happen is you can inadvertently become a public company. I think Facebook was facing this issue, among others, where you get more than 500 record holders. They moved the exemption now to 2,000. And I've had a couple clients that have accidentally become public companies. When you say accidentally, that means they didn't do it through like an IPO or something. One of the things you might want to consider in your private companies that are growing is, even with the 2,000 limit, which would solve a lot of the problems, is a lot of times have a redemption right or certain restrictions in your bylaws that you can deal with if you have these types of regulatory issues. A couple other overview items, and we'll get into them, is Form D. There's changes to that, and we'll go into that. There's new bad actor rules. Basically, if you get convicted of a felony and certain items that have to be disclosed or could prevent you from using certain exemptions. We talked a little about crowdfunding. I'm also going to be talking about insurance, which most clients have not had their insurance policies properly reviewed and don't really know what they truly have coverage for, and we're going to go through some of those examples. Rule 506C. Like I said, you can now do general solicitation. You could run TV commercials, advertisements, whatever you like, basically, and generally solicit for a private placement. Again, that doesn't sound right because it's a private deal, but now you can generally solicit. You can only make the sales, though, to accredited investors. And what that means is no longer could you like in some of the 506, you can do non-accredited, which I really don't recommend in most deals having non-accredited. They're the most likely ones to complain and cost you the most headache. And almost by definition, a non-accredited investor isn't going to put up a lot of money to move the needle in terms of the capital formation. But you do now have a increased level of scrutiny to make sure that the person actually is an accredited investor. A wink and a nod isn't going to cut it. You got to go through some reasonable steps to verify accredited investor status. We have some concerns that if you do an offering, it turns out someone's not an accredited investor, what will happen? So we don't have a whole lot of case law yet on what this means. We're somewhat leery of this, and we have heard, like Mary Jo White, the chairperson of the SEC, she really doesn't like this section. I mean, I think she's come out flatly, hasn't she, Emily, and just said she don't like it. And these rules are delayed, and they're concerned that there's going to be abuse or issues out there. One of the big changes, also, second big change, is that the Form D, which in a regular Reg D offering, there really was no penalty or whatever if you didn't make your filing with 15 days post-sale of the stock, except for New York has its own interpretation that you have to file ahead of time and pay a big fee, but New York has its own special rules. But nevertheless, you have to file for 506C. You got to lock in, and you have to make the filing 15 days prior before you make any offer. Again, we don't know how the case law will come out on this. What happens if you actually made an offer before you filed? Does that blow the entire exemption, and now you just did an illegal public offering? And the answer very well could be yes. We have seen a few of these. I've seen a few 506C offerings. They're not very. I haven't seen very many, but I've seen a couple in my practice.
Next section is Title III, crowdfunding. This is a very controversial provision for the Jobs Act. Everybody's very excited about this because they think it could be the next Uber or something exciting like that. Basically, crowdfunding is the raising of capital using internet or social media. Here we're talking about non-AIs, just like Michael said. These are not accredited investors. They're basically amateurs. You're trying to reach a crowd through the platform of the internet. So you've got, a broad reach of audience, but, these people are not sophisticated investors, and they may not be writing you large checks. So the rules have come out, the final rules have not come out. The proposed rules came out in 2013. The SEC has said that they are hoping to come out with final rules later this year, but I'm personally not holding my breath since they are understaffed and suffering from budget cuts. Basically, so here you're going to use the social media and internet to raise capital to a crowd, smaller amounts. Here we've got amateurs writing you small checks. These are the guys who are most likely to complain. And you've also got a limit of you can only raise $1 million in any 12 rolling months. So I don't know that this is going to be a super useful way to raise capital. In addition, the intermediary must register with the SEC as a broker or as a funding portal, and those rules have not come out. And, as Michael knows, the broker rules for registration with the SEC are not insubstantial, and they take about 12 months. So I don't know. It's really going to come down to whether people are going to use this provision. It's going to be the cost of compliance versus the ease of technology. I'm more of the naysayer kind of. I don't think this is going to work, but who knows? I didn't think, when someone said to me, what about Uber? And I said, Uber is great. I would love to have a personal car anytime I wanted. But what about, car accidents and you hit someone? And so I'm more the liability nervous person than but look at Uber. They're now worth $50 billion. So what do I know?
Well, at the crowdfunding, one of the examples I use, if someone invests $50 and it's a private company, how much information you have to get them, and then two, just even, transferring their stock certificate. It all costs money. Now, what the great hope out there, what Emily is referring to, like the Uber, will the technology bring down these costs? But, I'm a little skeptical of the cost benefit of getting all these unsophisticated small investors in it, but it's going to go forward. There's a lot of pressure, but we'll see what the final rules they come out with.
Right. So do not use this exemption because it has not come out yet. So we still have to wait.
People think it's active already.
I know.
They're out there doing their private placements and getting interviewed in the press and say, well, I'm crowdfunding, it's legal. Well, actually, it's not.
Yeah.
So
do not rely on this exemption. Practice tip.
Insurance. Most of the time, especially new clients, I find they have not adequately thought through all their insurance coverage. Fraud insurance, for example, I had a client said, do you have fraud insurance? Well, they did. They had $10,000, and then when they got ripped off for $1 million, they, had a nice big fee they had to pay or, absorb. On D&O insurance, a lot of times you have directors and officers get coverage, but clients forget to get entity coverage. And one of the things that we see the government doing is they will come after the entity and then skip the directors and officers, and you actually have no coverage. So this is a hole in your policy. The other is, as one of the bullet points here indicate, government investigations. A lot of the older policies were written for litigation when people would just sue you. Well, we're finding here in Washington there's a lot more government investigations which are basically tantamount, it's full-blown litigation. And actually you're kind of behind the 8 ball because you don't have all of some of the discovery protections and other protections that federal court or state court might give you, but they love bringing, we're just here to investigate you and help you. And it may cost you $1 million plus to handle that, and your insurance may not cover it. Meaningful amounts, I usually like to have high deductibles, but large catastrophic coverages because, it's a way of managing your cost. And if you don't have any money, I believe bottom line, and this may come to a shock to everybody, you will lose. If you go, if you're not represented, you got a problem, or you can't afford, decent counsel. The last bullet is the government really does have the ability, and it's really pretty shocking what they can do. They can come in basically and seize all your computers. They can swipe all your cash. They can take everything out of everything, and then you're supposed to defend yourself. And we've had a client that has happened to, and I can tell you right now, once they do that, if you don't have insurance, because they can't seize the insurance policy for paying for the lawyers to defend it, they can't get that money, but they can get all the other money. So if you don't have insurance, insurance may be the only thing that you have left standing to protect yourself. So I strongly urge you to, look at your insurance policies and have legal counsel review it to see what you got. This is the forfeiture laws, which have, started back in the war on drugs. Basically, that they could seize your car. They find, pot in your car, and then they just take your car. So goodbye, Porsche. There's your penalty. Now, recently, though, the Attorney General reversed the long-standing policy. We had 30 years of this, and as the slide says, it barred local and state police from using federal laws to seize cash, cars, and other property without warrants or criminal charges. So this is a major change that just occurred in terms of, the 3-decade war on drugs, and it wasn't just drugs they were going after. There's all kinds of things. Computer chips can be controlled, systems, software, everything. And the government has made a lot of these seizures to fund local and governments, et cetera, and it's been quite controversial, but we may have just gotten a little bit of relief from it. And one of the last bullet here, people have I'll just give you another example. A guy was driving down south to buy a franchise, and he had $20,000 in cash, and he got pulled over. The cop saw that he had 20 grand, seized the cash, wouldn't give it back. He was never convicted of anything, and they said, well, if you want your money back, we'll settle for $10,000. He said, what do you mean $10,000? You took 20. Oh, and the worst news is he lost his deal because now he didn't have the money and he's now fighting with the police. And this has been a mess and unfair, and it seems to violate the due process and their Bill of Rights, but I only got a B in con law. One of the things that I always point to on legal tender in the United States, because there's kind of a war going on for cash, that you're not supposed to have cash. You know, if you have cash, the cash is guilty of a crime, and it's not protected under our Constitution. At least that's what I read. And you know, but I circled here. If you look at it, your bill, it says this is good for both public and private debt. So this is our currency, and you're supposed to be able to use it, but they're making it basically criminalizing it if you carry cash. But that's what we've got. Kind of already covered some of this, but one of the cases out there for, you know, shutting down a business with crowdfunding and just seizing everything is the Selmo lending case. It was the Ohio division that basically went in and shut down this lender or person doing these deals. And one of the things is, with all this internet and everything else, you know, they had videos of the person talking and saying what you could do, and basically it was a 101 violation of the securities laws on some of this stuff. So, you know, it's on the YouTube, it's there, they got it. It didn't really end well for the company. But the fraud exemption, even though people think that everything's been preempted by the federal law, fraud is still actionable by the state governments, and that's what they're using a lot to come after you with.
And that's a concern that a lot of people have. Is crowdfunding going to get killed by 50 states and, you know, those state securities laws, and that is just going to bring it down and just be totally unmanageable to raise any capital when you've got 50 states in your business because of the breadth of your audience?
Again, on this forfeiture, you know, if someone comes in and wants to search all your records and if they don't have a warrant, I'd tell them no, or at least contact your attorneys first. You know, I've had a client, for example, who allowed them to go through all their books and records, and the guy said something like, well, where'd you get this number from? And he said, well, I made it up. And he was being sarcastic. The next thing we know, that's in the complaint, and now they're saying, well, he just made up his numbers. He admitted. So it reminds me of my cousin Vinny when they said, I shot the sheriff, and they said, well, he confessed. And he was just repeating the statement, and now they said that it's an actual confession. Now, Emily loves this slide because it's orange.
I did. I thought maybe the orange, this is a good time to wake everybody up with a bright orange whistle. So now I'm going to talk a little bit about whistleblowers. The SEC Office of the Whistleblower was created in 2011. It's basically an opportunity for employees and officers of a company to blow the whistle if they feel that there's some sort of fraud or other information that's going on at the company that needs to be reported to the SEC, but their upper management is not doing anything about it. So basically, what does this mean? So if you want whistleblower protection, which we'll get into in the next slide, you have to basically, you know, report to your higher ups, and you have about 120. You have to wait 120 days to see if upper management will make the changes that you've requested, or, you know, the items that you've flagged as a concern. And if these 120 days have passed and you feel that there will be substantial harm to the company or the stockholders if it's not reported to the SEC, then you have a right to call in a whistleblower tip to the SEC. So there are a couple of policy concerns with this, right? Because we don't want to be turning employees against their own employer. You know, they shouldn't be out to get the monetary reward that comes with being a whistleblower. They really ought to be, you know, in-house, you know, helping the company make, you know, comply with all of the securities regulations out there. And so what's happened, though, is because there are such strong protections for whistleblowers, it's very difficult to fire them. You know, there can be no retaliation whatsoever. That's penalized very heavily by the SEC. And states and other agencies also have these laws.
One of the things like we've seen is, for example, that, you know, what do you do when the general counsel becomes your whistleblower? I mean, that's very difficult to deal with. I mean, they've got all kinds of confidential information, et cetera, about what, you know, what you did, and it's really problematic.
I will say, as company counsel, you know, generally you do want to, you know, this is good to be reporting problems, but, you know, it's just another roadblock to operating a business. I mean, what if you have a disgruntled employee? What if the employee is just dead wrong? So now you have the SEC in your books and records. You have to spend hundreds of thousands of dollars on, on compliance and legal fees to basically clear your name because somebody might have just screwed up. So, I mean, it could kind of really cut either way.
Well, one other thing I want to mention is there is an intrastate crowdfunding. Some states have that, but I haven't seen very much of that being done in the marketplace, and that's up to your state by state.
So my favorite topic, the SEC Division of Enforcement, created in 1972. As we said, the Office of the Whistleblower was enacted in 2011 under Dodd-Frank. The whistleblower is provided with confidentiality protection, not unlike the Witness Protection Program, which is what I always think of, and they also have strong retaliation protection. You see, just recently, maybe last month or two, there was a case against Paradigm Capital Management in which, a whistleblower was, stripped of her job duties and demoted and, all of these awful things for blowing the whistle. So she was awarded over $600,000 just for the retaliatory actions, and that's separate from the money that she collected for being the whistleblower. And generally, they get cash awards of 10 to 30% of the money collected by the SEC. You'll see a couple of recent cases. The first time a corporate officer got a whistleblower award was in March. It was about $500,000. And then in April, a pretty big award, $1.4 to $1.6 million, was given to a compliance officer. So this is the person who is precisely responsible for compliance with securities regulations in-house.
Well, and one of the things to mention on this, on these whistleblower, there can be state whistleblower, there's SEC we're kind of focused on here, there's other causes of action, but under the SEC rules, the person could be completely out of their minds that blows the whistle, has no, let's say, no grasp of reality, has nothing to do with anything, doesn't matter. That person probably just bought themselves a couple more months of employment. Let's say they were on the employment bubble. You fire a whistleblower, or it ends up they actually had something, you're in trouble.
So the last slide about this is just some stats. One whistleblower has received $30 million, which is the largest cash award ever given. There's been 3,620 whistleblower tips total and a 20% increase in the last 2 years. As company counsel, I would point out that that's over 3,000 incorrect whistleblower tips, but I think it just depends on where you're looking at, where you're looking from. And so 40% received awards for current or former employees, 20% coming from contractors or consultants. And the whistleblowers are generally expected to raise concerns internally first, but it says here it's 80%. So, I guess people could say, Dodd-Frank has been pretty successful in weeding out fraud in securities cases. They have had a total of 17 whistleblowers, paid over $50 million. So you can assume that, the SEC has collected over $100 million, weeding out this kind of fraud. So why are we talking about this with the Jobs Act? Basically, we're just Michael and I are trying to lay out that, the landscape right now is tough. It's tough to operate a business in the United States. It's tough. You've got all of these, regulations to comply with, and you've got all of these laws out there that make it hard to operate a company. Right?
Yeah, they want us to do more IPOs, but yet at the same time, you've got all these attacks that you can come under. So it's kind of they're talking out of both sides of their mouth. I think I've seen some reports that we have fewer public companies than we did 20 years ago. We're seeing a decline. Now, right now, the market's doing well, and we're seeing actually more IPOs and more capital formation. So the market's doing relatively well. But I will say that I think there is a tendency for the market to, for these companies to be bigger, because they got to be bigger because they got more overhead to absorb to deal with all these rules. 20 years ago, we used to take companies public that were worth, $100 to $300 million. The new line is really, if you don't have a $1 billion market cap, we're not really seeing a whole lot of companies go through the public route yet. We see private equity or big refinances on capital formation through debt. So we're seeing that private market fill that early stage. And then you also see, part of the Jobs Act, they wanted to try to make it easier to be public. Well, I wouldn't say they've relieved us of a lot of that. You're seeing the big, huge companies buying up the, single billion-dollar companies, or the ones between 1 and 10 billion. I do think some of the regulations out there are one of the reasons you're seeing that. This is some example. They went after a bunch of mining companies. They also have, just to give you a sense of what they're doing, one of the kind of scary in a way, the third bullet here where they said they went after some lawyers, basically saying if you have improper professional conduct, they can come after you, the SEC. So we're starting to see a little bit of federalizing of bar licenses basically, and there are some things in Sarbanes-Oxley that also gives the government, the Fed, some reach into dealing with lawyers. Section 4A2 is the statutory reference where that's where you have a right to do a private deal under the SEC, under the rules, under the statute. Reg D, I always have to remind people, that's quote the safe harbor. That's not, just because you violate Reg D doesn't mean you're guilty. It's mainly Reg D helps you deal with a lot of your compliance on the blue sky, and again, Form D requirements. Mary Jo White is famous for saying that changing the no admit, no deny policy, since the early 1930s when the acts first came in place, the SEC and the private sector basically work together to work out issues or try to make, prove things or deal with things. But really, over the last 3 years, it's at least the SEC basically wants convictions. They want admissions of guilt. They want, in the last recession, the populist view out there is not enough officers of companies went to jail, so they want jail. They want jail, fines. In some ways, it's good for our business because this means there's going to be more litigation. If you can't just settle for money and fixing the system, and you're going to say to the CEO, well, they're coming after you, they want to put you 5 years in prison, I think they're going to fight that for a while. Some of the focus has been where large investors are harmed, markets at significant risk, and then at the same time, they turn around and they say we have this broken window strategy where the smallest infraction, they're going to come after you hard. So to the practitioner, I sit there and go, wait, you're going after the large and try to protect, but also if we make any mistake whatsoever, they're going to throw the book at us. And yet at the same time, they passed the Jobs Act saying we want to make it easier for you to raise capital in the public market, but the attitude is they want to create whistleblowers, and they want no broken anything you miss, they're going to come after you.
I do think it's a little bit ironic. I mean, my favorite analogy about Mary Jo White is, what is the speed limit on the highway? It's 60 miles per hour. Do people go 70 miles per hour on the highway? Yes, they do. Is Mary Jo the equivalent of a state trooper standing on the side of the road and willing to ticket you at 61 miles per hour? Yes, she is. So on the one hand, here's the Jobs Act. Welcome to these provisions. Take some exemptions. Step on in and then step into this quicksand. We got all these traps for you. So, it's kind of, like you said, talking out both sides of your mouth.
So, kind of getting a sense of what I think about that policy, and so I'm taking the Metro, and I see this sign posted all over Union Station Metro, have you seen Mary Jo White? And I thought, oh, this would be interesting. This must be, maybe it's someone who, agrees with me or thinks, oh, we need to, we've gone too far. But not, well, to my surprise, when I logged on, this was just the opposite. This was, Mary Jo hasn't done her job. This is highly critical of Mary Jo in terms of saying the theme of this particular ad is dark money and political contributions, and that they want Mary Jo White to force companies to disclose what they've given in political contributions, et cetera. And from my point of view as a securities lawyer, securities law is supposed to be about the company and what you've done. This group is trying to push the SEC for other political reasons that I would think is more appropriate for other legislation and leave the Securities Exchange Commission alone. We had a similar problem with legislation that had passed, the conflict minerals, where they wanted public companies to disclose the sourcing of where they got certain rare earth minerals or gold and other type of items, and eventually the courts actually ruled that law was inappropriate because it didn't really tie into the companies. But the cost to like that conflict minerals to comply with it was billions and billions of dollars. So there is a lot of pressure. So there's, for as much as I kind of say I don't like what some of the things Mary Jo White, I think they're also under political pressure to go even further.
So this next slide is just some bottom line, recent reporting on the SEC's Division of Enforcement. It's the largest number of enforcement actions to date, 755. They've gotten over $4 billion. Steady stream of guilty pleas, and as we'll see later, 100% win rate for the SEC in their administrative law proceedings. Basically, the SEC is a prosecutorial arm now, and they're coming after you, whether it's a foot fault, if you're late for a filing, or if you've committed a massive Ponzi scheme and defrauded people of $2 billion. I mean, to the SEC, you're the same in their eyes, and they're coming after you for both.
Yeah, one of the points on the bottom where it says a new financial reporting and audit task force, they're using computers and big data, scouring things with formulas to look for infractions, and there's a whole task force setting this up. Well, it's already set up. I mean, it's up and running. This slide is mainly just to show how much money is being raised where, and you can see that the private deals, Reg D and Rule 144A, well, some of those are semi-public, but it could be public. But there's a lot of money in private deals out there. 506 is still the most popular way by far. It's like, what is it, like 90-some% of all offerings plus. Very few deals are ever really done under the, even though we'll spend as lawyers on conferences and whatnot talking about the other Reg D sections, but 506 is still the most popular. This is just to remind people that there's a new electronic form, or relatively new. And, keeping records of all this stuff is actually pretty important. Keep your records, some of it's posted online, but you really need to keep records of, people, if they said they were accredited or non-accredited, whatever it is. I've seen offerings done where the people, said they were accredited and non-accredited in the same form, or said it was all accredited, and then you got the forms and they checked the wrong boxes. I mean, this stuff becomes a nightmare when you're trying to take a company public, let's say on the IPO ramp or something. They say, well, what were your prior offerings? And then the lawyers go through and trying to put it all together. And frankly, just looking for signatures can be a nightmare on documents. One of the things, and I think this is new on the form. I don't remember it in the prior ones, but there is becoming more and more, just like the CFOs for public companies have to certify statements about the financials of the company. You now have to certify and agree to serve as a process, and you got to knows the content to be true. So, what does this mean? I mean, you're certifying. I mean, you say, well, you now certify that's an accredited investor. How do you really know it? And if you really knew that the guy, he or she may not have been, you got a problem. Bad actor rules. Emily.
All right, let's talk a little bit about bad actors. As Michael alluded to earlier, these are the guys who have gotten in trouble with the SEC before, felons, people who generally cannot be involved in the purchase or sale of securities. When I say gotten in trouble with the SEC, I mean you've done things like, forgery, perjury, fraud, insufficient disclosure. And when you've gotten in trouble, you could be slapped on the wrist, you could be fined, you could be, you could be subject to an injunction of 5 years, 10 years, it could be a time period. You could be prohibited from serving as an officer or director for your life, I mean, just depending on how bad the infraction was. So as a practice point, we recommend that you document and verify that no bad actors are involved. I mean, as awkward as it is, you may have to go to the CEO of a company and say, has anyone in upper management been convicted of a felony? Is there anything I need to know about? Do you have any SEC proceedings or orders or injunctions that I need to know about? And the SEC is probably going, the CEO is probably going to look at you and say, I don't know, and then he has to turn around and ask these very awkward questions to his upper management. But you absolutely have to do this. In order to qualify for the exemptions under the Jobs Act, you have to disclose all of this information. And on the next slide, you'll see that there is a waiver process where you can request a waiver from your bad actor fines. And so bad actor waivers are also very controversial among the SEC commissioners. They don't always agree. Some of them are more willing to grant them than others, and this is basically a waiver to let you back in the game and let you purchase and sell securities and be part of the securities markets. But generally, they agree on the policy, which is to prevent recidivism and restore trust in the markets. I mean, we need everybody to believe in this system, and we need to weed out fraud where possible. So Mary Jo has told us that she's going to grant waivers based on the facts of the case, who was responsible, the duration of the misconduct, remedial steps taken, if any, whether it was an isolated incident or repeated offense, and the impact if the waiver is denied. Here, it's actually surprising, Mary Jo is more of the softie. So if you get Mary Jo, you're probably in the clear and you might get it, but other commissioners are more difficult and are less willing to grant them. They have also the SEC has been under fire recently for granting them to the biggest, baddest boys on the block, the biggest banks, the ones that are responsible for the most massive, schemes of fraud. Those guys do seem to get their grants, whereas, smaller guys with less infractions don't. So what we're telling you now is the waiver game it's like a crapshoot. It depends on if it's a cloudy day or not, and we can't tell you if you're going to get it or not because the commissioners are running around with their heads cut off and can't figure out what to do.
Well, and then the problem is, let's pick on the banks for a second. What are you going to do? Knock out a bank from ever, doing any kind of securities ever again? And, we did that with, Arthur Andersen. We took the entire company down, or the government did. How much of that do you really want to happen? And that's a big question. So, if you get, companies are made of human beings and they've got problems and they do incorrect things. Are you going to take down, $100 billion company because one person left the reservation? Or is it a chronic problem? This is a tough balancing act for the government, but, there are those who want more draconian actions taken. So you can, they're struggling with it. 144A, this was actually a nice change, I think, for the big institutions. It used to be the rule is you could only sell to a qualified institution some of these blocks. There's a private market for moving big blocks of private debt, and you were not allowed to offer it to a non-qualified institutional buyer, but now the rule is you can offer it to them, but you can only sell to a quib. So this makes it easier so that if there is a foot fault, but as long as you didn't sell to that non-qualified, you're okay. So this is actually a pretty nice change.
Okay, we just wanted to spend a minute on commissions. This is the amount paid to brokers who connect investors with funds and other people who purchase U.S. securities. We just want you to be aware that the SEC is cracking down on this and that finder agreements are being attacked. It used to be the case back in the 80s and the 90s that you were not permitted to pay a commission, but this was not what the SEC was going after, so people kind of did it under the table, and you didn't get in trouble for it even though it was technically illegal. Well, that has completely changed, and not only are brokers brokers and their finder agreements are being attacked, so they are being fined and being deemed bad actors. They have to give the money back. They have to pay a fine. Managers of private equity funds are also being punished for this. So if you pay or receive the commission, you're basically subject to the SEC's jurisdiction, and they're going to go after you for this. And, just so you know, the SEC is policing this for all U.S. securities, regardless of where the securities are sold. A lot of times, funds are being raised in China and elsewhere, but if it's a U.S. security, the SEC is saying that they have jurisdiction over you because of the U.S. securities, and they are coming after you. So bottom line, this is another kind of, roadblock in the way of operating a business. It makes it tough to raise capital. So it's very confusing how we have these regulations under the Jobs Act that, permit smaller businesses to get into the game, and for what? So, this game is so tough with the SEC breathing down your neck for every single thing. here we've seen a lot of pushback from clients and from other lawyers who say, you know, what is the big deal? I mean, we used to do this in the past, and you have to explain to them that it's a completely different time now, and this kind of behavior is not permitted anymore by the SEC.
And under the crowdfunding rules, they're going to basically, you can't really pay a commission.
You cannot.
And that's going to be one of the issues that you face with the new crowdfunding rules. There's certain issues related to how much the person who polices it's the portal that keeps it. I think they have a limitation on how much they can get paid as well. Well, the SEC, though, is on a tremendous winning streak. You know, I wish my teams had this kind of winning streak. They won every single game. So they bring actions, and there's been, you know, as the slide points up there, they won all 219 cases. That's quite incredible. And those of us who are highly skeptical think, well, someone must be cooking the procedures. I mean, I find it very hard to believe that every single one of these was valid. This is going in front of the administrative law judges that the SEC has put in place and through their rules and procedures, and we're seeing more and more of this type of these actions, especially since now they can get penalties through the administrative law action as well. The other thing that is going on, and this goes to the government investigation, you may not know that they're investigating you for years, and they basically work and work and work on their administrative law proceeding, and then they drop it on you, and you've got 4 months to prepare. So good luck. So in terms of context, we talked about the IPO, route that was part of the Jobs Act, and I think that has actually been a good benefit. They want to try to create more jobs. I mean, it's called the Jobs Act because they think raising more capital, but 506C, we really haven't seen a whole lot yet of activity in there. Now, some of that's not the fault of the government. I think we're waiting for the case law to come out and see how that's actually implemented. I'm a little nervous, though, that it's going to not be very favorable to the companies because there'll be a bad case, someone got ripped off all their money, and that's going to make the practitioners very nervous in terms of using that general solicitation. The crowdfunding, which Title III, we're still waiting for the final rules. We highlighted some of the main items in terms of there's a limited amount of money. It's a lot of non-accrediteds we expect will be in that, and the cost of complying or trying to raise such small amounts. Title IV, which was 144A, plus, which is changing it from $5 million to $50 million. The jury's still out, but I think that's a good change. I think that'll be fine. And then, raising the 500, Title V and VI, raising the thresholds, I think that's been good. However, what we've tried to put in here in this presentation was the context in which the Jobs Act, because you can't just look at it in isolation, and we think it's getting more complex. The demands for good records is growing. I think the SEC is coming after, as they say, every broken window. It's hard to explain to clients, just the fault can cause you a lot of problems, but, I'm just the one that read the back of the Monopoly book and the risk game book, so, those are the rules, and that's the context that we're dealing with. Raising small amounts of money from non-accrediteds, again, I think can be dangerous. Sticking with the accredited investors is a good idea. Also, just the accredited investor rules, those amounts were set back in the early 80s, and they haven't been changed. There's not very much pressure to change them so far that I've seen. But, it used to be if you had a single person earning $200,000, that was a very high amount of money in the early 80s, but that has not changed. Emily?
Well, that's it, really. Understand this SEC's current exam priorities. They're basically coming after people for every single foot fault, every single late filing, and so the hope is, I don't know if did we describe the broken windows strategy, which is, if you leave a broken window, others will think that no one's there really watching the place, so that they can rob the actual house. And so Mary Jo's intent is to fix every single broken window, meaning like a minor infraction, so that people know that they cannot create or they cannot commit bigger Ponzi fraud type schemes. I personally don't think that works in the SEC arena. I mean, in that setting, and I don't think the analogy works because I don't think that the people who miss a filing by one day are the same people committing massive Ponzi fraud schemes. I mean, I just think there are different sets of people. So I personally don't agree with Mary Jo's broken windows strategy, and I don't think it works in the SEC setting.
So one other comment on broken windows theory is even in the criminal arena, they're not sure that that actually even works statistically, which is kind of ironic, even though it makes kind of a nice sales pitch out there.
I will say, just as a bottom line, you know, I do think people are using the Jobs Act's provisions as they are coming out, which is a good thing. It's far too early. I know it's been 3 years, but it's far too early to see whether this has really led to job creation. Michael and I joke because when I first heard of the Jobs Act, I thought it was some sort of like unemployment legislation, like completely but it's actually securities regulation. So hopefully easing some securities regulations to get smaller companies in the game, and then tangentially create jobs from those changes. So that is our presentation. Does anybody have any questions or comments?
Well, one question that's out there is, what is, crowdfunding in terms of, Kickstarter, for example. People do that. Isn't that crowdfunding? Well, it's different. That's a lot of like Kickstarter is someone's got a product they want to develop, and you basically are buying in advance the product that they have to sell. So like they're inventing, X type of tool, and you say, here, I'll give you $100. I'd really like that tool. And then the person goes out and tries to raise enough money, and they usually have a minimum amount that they say, I need X amount before I can even make the tool. That's not crowdfunding under the SEC. So that type of funding is going on through the internet. Another question that's out there is what type of the response to the internet. In other words, the SEC is trying to deal with how much information is getting out there for deals, even when they're private. But remember, the SEC is out there trolling, and especially the states, are out there trolling websites to see if you're making offers on your website. And then they print out your website page, and then you got a problem.
I think the crowdfunding provision has really captured everyone's imagination, and they just, it seems like it could be limitless in terms of what it could, it could really take off. I just don't know, with the $1 million limitation in any 12-month period, I don't know how much money you could actually raise to get a company off the ground.
Well, a lot of times it's usually products or something or a company that people readily understand. Captures someone's imagination, is simple to sell. That's usually a lot of times crowdfunding or Kickstarter, things like that will go for. One of the things out there that I don't sell insurance, and I'm not an accountant, but you've got to have good accounting. And the SEC, when I first started practicing, we'd get comment letters from the SEC, and about 3/4 of the comment would be language or risk factors or perfecting this language. Now 75–80% of the questions are all financial, all accounting. So the sooner you get your accounting in shape, the better, and frankly, the more you have audited statements if you're a private company. And even if you never have dreams of going public, if you have audited financials, when you sell, especially if you're going to sell to a company that either wants to be public or going to go public, you will get a higher multiple of EBITDA.
Go ahead.
I
was just going to say, we should also mention that Mary Jo is not a fan of crowdfunding, and she's very concerned about, the potential fraud that could be coming in that way. She said, she's really worried about that, and I wonder if that's part of the delay in getting the regulations out, because she's kind of dragging her feet. She doesn't want these regulations out there and for people to be using this exemption because she's very concerned that this could be wrought with fraud.
Yeah, and then people could be harmed. I mean, that you start taking in all these non-accrediteds, and they put up their last $1,000, and they get, they lose their money, and now what?
Well, there could be one that's, that completely takes off, and then 10 that completely fail, and people lose $100, $1,000, and there's just nothing that anyone can do about that. And then, the SEC, there's going to be a lot of pressure on the SEC to go after the fraudulent ones or the ones who just fail. I mean, sometimes businesses just fail. It's not a guarantee that you're going to get any return on your investment.
Yeah, just a general comment on the Securities Exchange Commission was not designed to determine the merits of an offering. Emily, what is it all about? The big D, disclosure, disclosure, disclosure. That's what it's all about. It's not about, you could have the worst concept in the world, but it's all about disclosure. The states have taken the position, it's called blue sky, is they can historically do some merit review, but the feds have been preempting the states. That's why we have the Reg D, and you can preempt the states, but they can still come after you for fraud.